Hi friends, my cap, last video of the series. That is good. I think 3 hours and something, that is enough for me and for European trademark. So you should by now know a lot of things. But there are some things which I could not find to put into, or had not time because I wanted to make the videos quite short, 15, 16, 17 minutes. The last videos were a bit late already. A bit full already, so I want to profit from this last video to get some more information on the different aspects I could not be much detailed of in previous videos. And the previous video precisely was about enforcement, and there are two aspects of enforcement which I still want to give you some more information. The first thing was that, remember the 6 aspects of the IPRET, of the intellectual property regulation of enforcement. So if this 5, I think 5 I have mentioned, and the 6th I have not been able to mention it. This is about the situation where you want to make a damage claim. You are the claimant and against the infringer, and you want to put a number on what is your claim. But you don't know exactly how to number your claim because you don't have the real evidence on what has been sold, what is the undue profit, what is your losses, because if you don't know what has been sold by the others, you can't calculate your losses, right? So there's a possibility, there's a difficulty here, and that difficulty has been seen by the European legislator that we need to harmonize this. This is one of the pressing issues with regard to the claimant. And if you want to have something which is a bit hurting with regard to the infringement, so deterrent to the infringement, that would be the possibility that the claimant is able to determine exactly what is his loss and what is the undue profit of the other. And the higher and the more close it comes to, the more deterrent it is, right? So here it goes. We have the possibility in the member states, so it has been transposed into the law of the member states, that the claimant can ask for the necessary information for the evidence to be presented to the court with regard to the undue profit. So that means the invoices or the distribution list or the turnover, or all kind of information which is necessary in order to be able for you and for the judge as well to assess what would be the claim, the undue profit, and the loss of profit of yours in order to get to this. So an important thing not to forget. The other is there's a counterclaim. So I didn't talk you really through the EU trademark courts. There are in each country, there are some, not very many, and precisely not very many, in order not to get all kind of case law spreading out from the different lawyers and don't have the necessary experience and then making a judgment. No, we want refrain from a lot of EU courts, trademark courts. So each country has some courts. And when I talk to the IP courts in each country, normally they also are EU trademark courts. So the Olge Düsseldorf, which I told you for Germany, that is a EU trademark court. So the EU trademark courts, according to Article 127 of the Trademark Regulation, they have the possibility the authority, so to say, to judge about the EU trademarks infringement claims. Now, if you you as a claimant, you have an infringement claim against the defendant, and the defendant can make a counterclaim by saying that your EU trademark, so the basis of your claim, is invalid because you have done it, you have filed for it in bad faith. So that is a possibility which is foreseen in the trademark regulation, which has to be presented then in the EU trademark court, and the counterclaim can be done within the same proceedings. And there was a claim very recently, that was in Austria, and it was about the Bäuchelwärmer, so it is a kind of a heater for tummy. That was a trademark. And about that, the defendant, also an Austrian individual, there were two individuals, the Austrian individual, they made a counterclaim. It made a counterclaim against the claimant by saying your trademark, your EU trademark, which is the basis of the claim, is invalid due to bad faith. Now, the court there was not very clear how to act on it, whether it should decide first on the counterclaim and then on the, so to say, main proceedings, or if they have to wait until the counterclaim expires all appeal proceedings and then go back to the main proceedings, or what to do. And what is in this case being done when they don't know exactly what to do with regard to EU trademark law, who is the one they have to go to? They have to go to the European Court of Justice in Luxembourg, which is the only authority which can interpret, and with a unitary character for the whole European Union, what is the right interpretation. And in that case, that is C/425/16. In that case, the court, it was quite late in the course, I must say, late that this has been decided by the court. It could have been much earlier come to the court. It did not. Well, it said that you, the national judge, right, it can decide on both at the same time. So it is not necessary to look for the counterclaim first and being expired an appeal and then go back to the main proceedings and give the claimant the green light, so to say. No, it is not necessary. You can decide on the same case. And then the grieved party is able to appeal, right? You know this, grief. That's important. So that was still on enforcement. Let's go now some other loose ends I have here, which is the priority. You know what priority is. You know what the filing date and the importance of the filing date is. So a priority 6 months before. You can have an earlier filing date for the EU trademark if you have an earlier filing in a national country. Identity, triple identity is necessary, you know that. So this is a possibility existing in Europe. And well, if you have an earlier filing date, you have all of those which come afterwards to the registry. Well, you get the priority, right? First to file. So that is a good thing. Next, I want to talk to you something about the many resources you have. And I would say you are quite, well, you should be quite happy. What is the situation now with technology? Some 20 years ago or 30 years ago, when I was in the beginnings of the IP, there was nothing like that. So with a mouse click, you can go to 96 million trademarks and see what is out there and what can be harmful to you. You know, these 96 million, it stick with you, right? So this is TMView. TMView, here's the website, and here is a search result if you want. And you can look from all different angles, namely with regard to, you can look for a special one, or can look on what is on the registry with regard to certain generic issues. So it gives you the possibility to go through a bit of everything and see limit to the jurisdictions where you're interested in. And well, I think if you have a good assistant and you get your assistant proficient with regard to the use of TMView, I think it can be a great service for you and for your client in order to pull out the necessary information for you to act upon. The other was the harmonized database, right? Harmonized database, that was the possibility that you have 70,000 terms which are pre-translated into 22 languages. So there are 23 languages out there. in the European Union, and you have these 70,000 terms in 23 languages. And you have, on top of it, you have it in the right classification. So once you use the harmonized database, you will not get objected with regard to the classification of your goods. It is pre-adopted, pre-accepted. The classification is pre-accepted, right? So another issue was the e-search case law. And this is one of my favorite, I must say, my favorite when I was in the EU IPO. So I was using a lot the e-search case law. E-search case law that gives you all decisions, I say all decisions of EU IPO since its inception. So that's a lot, right? So that are, I don't know, 60,000, 70,000, or even more. I don't know. There are a lot of decisions, probably more than 100,000. So there are 100,000, can you imagine, 100,000 decisions which has been taken by EU IPO on trademark issues. Now, the court decisions, so general court are also in there, right? National courts, enforcement database, the enforcement decisions from national rulings, national courts, they are also in there. And designs also, but that is not the issue here. You have a lot of this, and you have a good chance that if you're looking for one specific issue, that it has been already decided upon. So why would you need to get a risk in this and that and think of, well, what I have to say, I don't know what the outcome is, if it is already in there. And also, so all the examiners are using it, right? And you have the possibilities, right, to go to a text search if you want. So this is the text I want, whether this has been done in the, this is included in another decision already, or you want to look per article this and that. You may want to look into the implementing regulation. There's also the possibility to look into that. Or you can look as limit is to opposition division. You can limit is to examination decision, or you can all of them if you want. You can limit the language. So there is all possibilities in there, which I want you to explore. It is very straightforward. I must say we have no necessity to give you any information how to do it. You just tick on advanced search, and then you get all on the left side, all the possibilities you have in order to filter your search criteria. So there's another thing, the guidelines. I didn't talk about the guidelines. It didn't fit into the video series so far. The guidelines are, you see the ranking of the trademark regulation. That is one of the top, or if you want, the court rulings are still on top of that. So trademark regulation, and you have the implementing regulation, so it is adopted by the member states, and you have the guidelines. The guidelines are something which is adopted by EU IPO, so in the ranking inferior with regard to regulation, right? But it gives you an idea, for example, if you want to know how EU IPO would react on a request from restitutio in integrum from myself. And there's not much case law out there, or you want to see what is on the mind of EU IPO with regard what is the threshold from which I get restitutio in integrum, and what is inferior to the threshold. So I will not argue about which is inferior, but I will limit myself to the arguments which can go beyond that. So, congratulations, you did it. More than 3 hours on this, and I think you know more than, a lot of percentage probably of people outside on EU IPO and their systems and the enforcement and the European community and, everything which can hopefully helpful to you in your practice, future practice. And even if you don't go through the whole course today, this is structured in a way that you can at any moment come back to one or the other point where you were not clear about, or where you have this concrete problem and you want to get some inspiration on how to act on that one. Thank you. Thank you for the court. Congratulations, and keep up the good work.